Good morning, good afternoon, good evening, everyone, wherever you're joining us from. Um, it's a wonderful to see a diverse group of participants joining us to this second session of the carbon credit training session. I hope you are doing all fine. Welcome to the second session of the carbon credit training series. We sincerely appreciate your time and participation in the first session, and here we are in the second session. So the second session will be led by our experts from A&O Shearman and the International Lawyers Project. And the second session of our webinar series will cover the following topics. 1, legal and regulatory frameworks. 2, market trends and future outlook. 3, risk management and carbon trading. So this training has been organized by the East African Wildlife Society in collaboration with A&O Shearman and the International Lawyers Project. And this meeting is being recorded, and all participants are actually guided to be muted at all times. So in case you are having questions, you can post them in the chat box, and our moderators will actually escalate the same question to our speakers. I take this opportunity to welcome you all to this second session of this webinar series, and I will love the participants to introduce themselves in the chat box as we get to know each other. Welcome, Jabez, as you introduce the speakers. Thank you very much.
Thank you very much, Vincent. I think without wasting time, I'll go straight to our speakers of today. So today's session will be led by two trainers. One is Ellis Al-Hari. Ellis specializes in complex investment, commercial arbitration, public international law, and business and human rights. Her experience spans multiple industries and sectors with a focus on energy and mining and metals. She also advises on the international protection of investments, including political risk mitigation and issues arising out of sanctions. I'm very sure when Elise will be doing her presentation, she can introduce herself further. Our second speaker is Alexander Makopoulos, who is also a counsel. Alex represents companies and states in commercial, investment, and maritime arbitrations carried out under the auspices of a variety of institutional and ad hoc rules, including those of the ICC, ICSID, UNCITRAL, SCC, and the LMAA. So without wasting time, Elias and Alexander, I would like to give you this opportunity to take us through the training session. Thank you.
Thank you very much, Tabis. Thank you, everyone, for being here today and for organizing this excellent event. It's our honor and pleasure to be here speaking with you about carbon markets trading, something that is fairly new, and we're excited to be speaking to you about it on the ground level in Kenya, as it is indeed in many places in the world right now. As Javis said, my name is Alex Makopoulos. I am a counsel at A&O Shearman. I've been practicing for over 15 years. The last 10 of those, probably more, in Paris, France. My background, my specialization is in disputes, at least by name, but I think what Elise and I tend to do most is problem solving and advice on how to manage risks properly and avoid disputes, which is the perspective from which we're going to be sharing our thoughts with you today. So you've already heard in a first session about, in broad terms, what carbon markets are and how they work. What I think we're going to bring to the table now at perhaps a slightly deeper level of detail is what is the lay of the land in terms of the legal framework, what are the main risks legally, and how does the law and other legal apparatuses function to manage those risks, and what we can expect in the future. Before we dig in, I wanted to hand it over to my colleague Elise to introduce herself as well and say a little bit about what she does.
Thanks, Alex. And to repeat everything Alex has just said, it's really an honor and a privilege to be speaking to you all today on what is, for me, a very exciting topic. My background is quite similar to Alex's. I have also been practicing at the offices of A&O Shearman, as it's now known, for about the past 10 years, have approximately 15 years of experience in disputes, but also with a specialization in business and human rights. And increasingly, as these issues become more and more important to our clients, the environment, climate change. So without any further ado, because I'm conscious of time, perhaps we can go to our first topic, which is in fact the international legal framework. So one of the most noteworthy features of Kenya's 2010 constitution is how it integrates international law into Kenyan law. In particular, and you can see on the slide, Article 2.5 states that the general rules of international law form part of the law of Kenya. This seems to be a reference to customary international law, referring to the principles and practices that the international community have accepted as binding on states. Article 2.6 then states that any treaty or convention ratified by Kenya likewise automatically becomes part of Kenyan law. So the 2010 constitution adopts what is known as a monist approach, meaning that international treaties ratified by Kenya can be directly applied in the Kenyan legal system without the need for separate legislation. This is a marked shift from the so-called dualist approach under Kenya's former 1963 constitution, where international treaties ratified by Kenya had to be incorporated through domestic legislation to take effect in Kenya. According to the monist approach under the 2010 constitution, Kenyan citizens can directly invoke and Kenyan courts can directly apply customary international law and any commitments assumed by Kenya under international treaties, including on human rights and the environment. The Constitution doesn't establish any formal hierarchy in cases of conflict between domestic and international law, but I would note that monism in its purest form dictates that international law is in fact superior to domestic law, including constitutional law, and prevails in any conflict. In practice, though, domestic courts may place differing weight on international law. I would note also that the potential for this kind of conflict is limited by the fact that, pursuant to the Treaty Making and Ratification Act of 2012, the Kenyan Parliament is required to debate and approve treaties before they are ratified, ensuring that international agreements align with Kenya's national interests and constitutional values. Okay, having laid that groundwork, we'll turn now to the relevant international instruments, starting with the United Nations Framework Convention on Climate Change, the UNFCCC. A warning, there are a lot of abbreviations and acronyms in this topic. But the UNFCCC is an international treaty adopted in 1992 at the Rio de Janeiro Earth Summit, specifically to address climate change. Almost every country in the world is a part of the UNFCCC, with 198 countries having ratified the convention, including Kenya. The main goal of the UNFCCC is to stop dangerous human interference with the climate system. It operates under a principle of common but differentiated responsibilities, which recognizes that industrialized countries have historically contributed more to greenhouse gas, GHG emissions, and should therefore take the lead in combating climate change. The highest decision-making body of the convention is called the Conference of the Parties, or COP. The COP meets annually to review progress, set targets, and negotiate further action. All state parties to the convention, including Kenya, are represented at the COP. Next slide. At the third COP in December 1997, the Kyoto Protocol was adopted. But due to a lengthy ratification process, it actually didn't enter into force until February 2005. 192 countries, including Kenya, are parties to the protocol. What the protocol did was it really put the UNFCCC into action by setting binding emission reduction targets for countries listed in Annex B to the protocol. And in keeping with the principle that I have just mentioned of common but differentiated responsibilities, Annex B countries were exclusively industrialized countries or so-called economies in transition, which were mainly Eastern European countries. There were 2 commitment periods under the protocol, 2008 to 2012 and 2013 to 2020. The second commitment was entered into pursuant to the Doha Amendment, so named because it was agreed at COP18 in Doha. Annex B countries were expected to meet their targets primarily through taking national action, but the protocol also notably provided 3 supplementary market-based mechanisms to help Annex B countries achieve their targets. The first was the Clean Development Mechanism, or CDM, which enabled Annex B countries to earn certified emission reductions, or CERs, another acronym, by implementing emission reduction projects in non-Annex B countries. And these CERs could then be used by Annex B countries to meet their own emission reduction targets, or alternatively traded with other Annex B countries. So in this way, the CDM promoted the transfer of technology and funds from developed to developing countries. Second, there was the Joint Implementation Mechanism, allowing Annex B countries to earn emissions reduction units, ERUs, by carrying out emission reduction or removal projects in other Annex B countries. And these countries could again use ERUs to meet their own emission reduction targets or alternatively trade them with other Annex B countries. Third, there was international emissions trading, which permitted Annex B countries that had spare emission allowances or assigned amount units, AAUs, meaning they had emitted less than their allocated targets, to sell these surplus allowances to countries exceeding their own targets. In reality, this mechanism was very rarely used. So under the Kyoto Protocol, we saw the creation of a new commodity in the form of emission reductions or removals. Just like other commodities, carbon was now being tracked and traded. I would note that while non-Annex B countries didn't have binding commitments under the Kyoto Protocol, they could still participate in this carbon market. So with the conclusion of the second commitment period of the Kyoto Protocol on 31 December 2020, the legally binding emission reduction targets fixed under the protocol effectively came to an end. Meanwhile, however, the Paris Agreement had been adopted by 196 countries on 12 December 2015 at COP21 in Paris. The Paris Agreement is now the primary international instrument for addressing climate change. Its main goal is to keep the global temperature rise to well below 2 degrees Celsius above pre-industrial levels, with efforts to limit it further to 1.5 degrees Celsius. Unlike the Kyoto Protocol, which focused on industrialized, so-called Annex B countries, the Paris Agreement imposes binding commitments on all state parties. Still in keeping with the principle of common but differentiated responsibilities, though, the Paris Agreement urges all developed countries to provide support and financial assistance to more vulnerable countries to help them reduce their own emissions and also to adapt to climate change's effects. The Paris Agreement operates on a 5-year cycle, with countries submitting increasingly ambitious climate action plans called Nationally Determined Contributions, or NDCs. And these NDCs outline each country's targets for reducing GHG emissions and the measures that that country will take to achieve those targets. Kenya submitted its last NDC in December 2020, committing to a 32% reduction in emissions by 2030 relative to the business as usual scenario. So just as the Kyoto Protocol had mechanisms designed to help Annex B countries meet their binding targets under the protocol, the Paris Agreement in Article 6 likewise introduces mechanisms to assist all countries with the implementation of their NDCs under the Paris Agreement. We have the Article 6.2 mechanism, named as it was established by Article 6, Paragraph 2 of the Paris Agreement, which allows countries to sell and transfer their GHG mitigation outcomes to other countries in the form of units called Internationally Transferred Mitigation Outcomes, or ITMOs. Like carbon credits, an ITMO is a unit representing a fixed quantity of GHG reduced or removed from the atmosphere as a result of an emissions reduction or removal project. Countries can sell their ITMOs to other countries that are either struggling to meet their own targets or perhaps wanting to achieve more ambitious targets. There is also the Article 6.4 mechanism, named, as you have probably guessed, as it was established by Article 6, Paragraph 4 of the Paris Agreement. This builds on the Clean Development Mechanism, or the CDM, from the Kyoto Protocol by allowing for the creation of certified emission reduction projects, which can generate tradable carbon credits. Unlike the CDM under the Kyoto Protocol, this Article 6.4 mechanism doesn't distinguish between developed and developing countries and can be used by all state parties to the Paris Agreement. Additionally, carbon credits generated under the Article 6.4 mechanism can be traded in voluntary carbon markets, which, to recall from your first training session, are markets where companies or other organizations and individuals can voluntarily purchase carbon credits to offset their GHG emissions. Following COP26 in Glasgow in 2021, a highly anticipated Article 6 rulebook was adopted, which provides detailed guidelines for implementing these Article 6 mechanisms, which are still very much under development. In particular, the rulebook establishes a robust accounting framework to ensure accurate calculation of and avoid the double counting of emissions reductions or removals. It achieves this by imposing a new requirement for corresponding adjustments. That is, when a state transfers emissions reductions to another state under either Article 6.2 or 6.4, it will need to make corresponding adjustments to its own emissions accounting to ensure that it no longer gets the benefit of those reductions. The rulebook also imposes requirements for eligible projects or activities to be included in the global carbon market mechanism under Article 6.4. In particular, the mitigation of GHG emissions has to be additional, meaning that they wouldn't have happened without or but for the project or the incentive of obtaining carbon credits. If a project is done purely to comply with regulatory requirements, for instance, it will not fulfill this so-called additionality requirement. Projects are also required to deliver real, measurable, and long-term benefits over multiple NDC implementation periods. Even though the rules under the rulebook are not strictly binding outside the context of the Paris Agreement, these rules might be referred to as international best practice, meaning that they may create expectations about their use with potential ramifications for voluntary carbon markets. On this final slide, we've set out some other sources of relevant international law which you should be aware of. In the interests of time, though, I'm going to leave you with this slide and hand back over to Alex, who will be walking you through the relevant domestic legal framework.
Thanks a lot, Elise. Okay. We're going to dive now into the domestic legal framework, which has, as you'll see on the next slide, 3 main pillars to it. First, and these are in order of superiority of the law, if you will. First is the Kenyan Constitution. We'll look briefly at that. Then comes, in terms of relevant legislation, the Climate Change Act, which was amended recently in 2023, notably to include more detailed provisions on carbon trading. And then even more recently, just this year, there was enacted a climate change carbon markets regulations, which set out detailed regulations, and as you'll see, quite detailed, quite prescriptive regulations on involvement in and operation of the carbon markets in Kenya. Starting then with the Constitution. So the Kenyan Constitution establishes a number of key rights, which ultimately end up forming the backbone of what is Kenya's carbon trading system. What I hope you've taken away from the tour that Elise took you through on international law is that that is significant as well as a source of principles, as a backbone, if you will, to the Kenyan carbon trading markets. What you saw there were certain obligations that Kenya has signed up for, that it owes internationally, and which therefore, in order to perform those obligations, in order to make good on them, we have to see corresponding regulations, corresponding laws within the Kenyan system. Well, some of those come from the Constitution itself, and others, I would say, are additional features to the Kenyan carbon trading system, which aren't necessarily international law obligations, but which come through because they're seen as immutable rights in Kenyan law. And one such right is the right to a clean and healthy environment, which is enshrined in Article 42 of the Constitution. In that regard, you see in Articles 42 and 69 some fairly specific requirements at the constitutional level, which lead to, for example, requirements like benefit sharing, which is a key feature of the Kenyan system, and a requirement for environmental impact assessment. You can trace all of these back to constitutional rights in Articles 42 and 69. Moving then to the next level of the framework, we have, as I said, the Climate Change Amendment Act of 2023. And this sets out at a high level requirements for the establishment and function of carbon trading markets. There are 4 main points that I wanted to touch on. Obviously, we're not going to go in detail through every provision, every section even of the Climate Change Amendment Act, but there are 4 things I wanted to leave you with. The first is that it establishes 2 key agencies, those being the Climate Change Council and Climate Change Directorate. We'll see how those fit into the system in a second. Third is that it governs the regulation of carbon markets at a high level. The regulations provide more detailed regulations. And fourth is that it addresses social and environmental impacts and benefits of climate change projects. So starting then with the key players, with the agencies. You have them on the screen that shows you how these agencies interact with one another. I'll start by saying that Part 2 of the Act is entitled Policy Coordination and Oversight, and that part is dedicated almost exclusively to the National Climate Change Council. And that tells you a lot about how important the National Climate Change Council is and where it fits in within the system. The National Climate Change Council is actually chaired by the President of Kenya. Its key functions include overseeing the development and implementation of the National Climate Change Action Plan, a key document, administering the Climate Change Fund, setting greenhouse gas emissions targets, and regulating carbon markets in line with Kenya's obligations under international law that Elise touched on. It also has attached to it the council secretary, who plays a very special role. He or she has functions that will interface with virtually every imaginable stakeholder in Kenya's carbon trading markets, from international to state level down to private interests. And those include formulating the National Climate Change Action Plan, which we'll dig deeper into in a few moments. Also coordinating climate-related negotiations together with the Cabinet Secretary for Foreign Affairs, and also reporting to Parliament on Kenya's relevant national and international obligations. You'll also see the Council Secretary is responsible for appointing Kenya's designated national authority. That's the National Environmental Management Authority you see on the bottom right of the screen. And we'll look at what they do as well further on in the presentation. And then the next key agency, which you see at the bottom of the screen on the left-hand side rather, is the Climate Change Directorate. And the Directorate really is the lead agency for national climate change coordination amongst the various agencies and various stakeholders. Its roles and functions are really focused on that coordination role as well as knowledge management. As I mentioned, we'll dig a little bit deeper into the National Climate Change Action Plan. This, to recall, is formulated by the Council Secretary. It's a keystone document within the Kenyan legal framework for carbon trading. As you see, it has a number of different but related purposes. And by the way, what you see on the screen is just a few of the more important ones. It has many, many more functions than this. But the key point is that this action plan is binding on the Cabinet Secretary, on all public bodies, and indeed on any person who's engaged in climate change governance and administration within the Kenyan legal framework, including individuals and agencies. It therefore has quite a far reach, meaning that the Council Secretary, who's responsible for this document, has quite a lot of influence over carbon trading in Kenya. I'd like to look now at some of the Act's provisions that create really the blueprint for how carbon trading can occur in Kenya. So far, we've just looked at the players, really. Now I want to look at the policies themselves. And we see here some provisions regulating one's ability to participate in carbon markets. Participation, as you see, it must be as a result of either a bilateral or multilateral agreement, or as a result of trade with a private entity, or in a voluntary carbon market. And again, we see the Cabinet Secretary having an important role here. They are empowered to enter into the agreements at state or private level to facilitate carbon trade. There are also requirements for how carbon trade must be carried out, not just who can be involved. A few of the key ones, and again, we'll share these slides with you. I'm not going to read everything you see on the slides. I just want to hit the few key points that I hope you take away from this. So the key ones here are that transactions carried out under the Act must aim towards actually reducing greenhouse gas emissions. Second, that emissions avoided by offset projects must actually be kept out of the atmosphere and must do so for a reasonable period of time, not just for a couple of days, if that's even possible. Third is that emission reductions must be carefully recorded in accordance with UNFCCC standards, and they must be recorded along with other key data in the National Carbon Registry that's also publicly available. So you see here also some recording and data keeping requirements. Another key part of the Kenyan carbon trading framework aims at ensuring that social and environmental risks and benefits are appropriately and indeed fairly allocated. There's a basic requirement for all carbon projects to aim to improve the environmental, economic, social, and cultural well-being of the surrounding community. There's also a related requirement for social and environmental impact assessments to be done before any project can proceed. And in addition, and I thought this was a rather interesting aspect of the legal framework, anticipated benefits must be identified beforehand, that is, before the project is approved, in order to ensure that during the course of the project, they are adequately allocated, including to the surrounding communities. As to those benefits, the Act requires project proponents to implement their projects through a community development agreement with the surrounding community. This agreement is integral. It's an important part of the system. It must be revisited and potentially amended every 5 years. It's interesting we see this 5-year rotation, as we saw also for some of Kenya's international law obligations. This seems to be seen as an appropriate time to rethink whether obligations are being met and consider whether the relevant promises need to be reconsidered. According to the Act, each such agreement must make provision for the community to receive a 40% contribution from all land-based projects. That would be projects like reforestation or land conservation, or a 25% contribution from all non-land-based projects. So you see a distinction there between the two different types of projects. And the agreement must also describe how engagement with local stakeholders will occur and how benefits will be shared in quite some detail. The final aspect of the domestic legal framework that I wanted to look at with you today is the climate change carbon markets regulations, which were introduced earlier this year in May. These are detailed requirements for the oversight of carbon trading markets, the implementation of carbon credit trading projects and businesses, as well as carbon credit trading transactions and benefit sharing. So as I did with the Act, there are a few key points that we want to look at in the regulations. There are details regarding governance and institutional framework. That's essentially part 2 of the regulations. Details regarding the carbon registry, the National Carbon Registry. Those are dealt with in part 3 of the regulations. There are then regulations concerning participation in carbon markets in part 4, procedures for developing carbon projects in part 5, and strewn throughout, there are some provisions on offenses and some penalties for non-compliance. Starting with participation, proponents, above all, are required to demonstrate environmental integrity, sustainable development, and alleviation of poverty. Those are minimum proof that need to be done when applying to start a carbon offset project in Kenya. And as we mentioned earlier, the key document there is the environmental and social impact assessment, which needs to show what the impacts would be and that they're adequately managed. Carbon projects must also be certified and validated by an independent auditor before a project commences. And this requires also a letter of support from the county, so on the local level, where the project is going to be situated. 2 interesting things about how the regulations deal with projects, starting with existing projects. So there are some carbon offset projects that are already in train and were before the regulations came into effect. Those have a 2-year grace period to align with the regulations before the regulations become binding on those projects. And in any event, they must be subject to an environmental audit within 6 months of the regulations coming into effect. There are also special requirements for land-based projects as distinct from non-land-based, just as we saw within the Act, which creates a distinction between those types of projects. Where the land is owned by third parties, project proponents must provide the agreements demonstrating the owner's consent for the use of the property in the carbon project. So that's a a condition precedent to the project being approved. For community land-based projects, there's a requirement to provide documentation of free, prior, and informed consent from the relevant community. And you'll recall so that the Act refers to impacted communities in this sense. I would note here that the Act doesn't define that term, which means that in complying with these regulations, it's up to project proponents to take a position on who the impacted communities are and to explain why they think they are impacted by the project. The regulations also, in my view, quite interestingly, provide a very detailed prescriptive process for the approval, implementation, and operationalization, of a carbon project. And we have up on the screen the main steps in getting a project off the ground. I'm not going to read through all of this in detail, but the main takeaway is that it could take up to 2 years, given the timeframes from step to step for a project to get underway. Some of that, however, is up to the project proponent. You'll see, for example, in the second step, that the proponent must submit project detailed design documentation within 12 months of receiving the first okay from the designated national authority, that being the letter of no objection. Once the project design document is submitted to the designated national authority, the DNA then has a relatively short time frame for dealing with it. So it has 7 days to send it to an ad hoc committee, who then has 30 days to make a recommendation. But then when the ultimate approval comes from the DNA, the project proponent has another 12 months to get the project commenced from receiving its letter of approval. So really, the long lead times are with the project proponent and not so much with the state and its agencies. There are also fees that need to be paid by the project proponent. As you'll see on the screen, the fee structure distinguishes between citizens and non-citizens, with substantially higher fees for the latter. And the fees need to be paid typically at 2 stages. First, upon approval of the project design document. That's where you see the project application fees, design document fees, and administrative fees due. And then the second time that fees need to be paid is within 30 days of a carbon credit sale, once the project is up and running and actually producing carbon credits. As to offenses and penalties, the main takeaway I think that we want to come home with from this slide is that there are 2 types of penalties. There's the basic default penalty for any offense for which no specific penalty is provided for in the Act or in the regulations. That provides for a fine of up to 20,000 shillings and or imprisonment of up to 6 months. So those are maximums, but note that they can be cumulative. You can get both the 20,000 shillings and the 6 months in prison. There are far more serious penalties for far more serious offenses, such as fraud, counterfeiting, etc. I would note, however, that failing to maintain carbon records is considered such a serious offense. So one should take care in approaching the relevant regulations when it comes to recording and sending data to the relevant agencies. And for that, the penalty is a fine of up to 500 million shillings and or prison time of up to 10 years. I'm going to hand it back to Elise now to speak a little bit about carbon trading related disputes.
The resolution of carbon market-related disputes. Many different kinds of disputes can arise in connection with carbon markets. They include contractual disputes concerning the specific terms of carbon trading agreements, such as pricing terms or provisions governing the delivery of credits. These sorts of Disagreements can occur, for example, when parties interpret contractual terms differently or fail to meet agreed upon conditions. Conflicts may also arise over the integrity of carbon credits, particularly around whether the emissions reductions meet quality standards or satisfy the requirement of additionality. So, i.e., proof that the carbon reduction would not have happened without the offset incentive. Determining additionality can be a very difficult exercise and can lead to disputes. The involvement of credible third-party verifiers and certification bodies can help prevent these kinds of disputes by ensuring carbon credits meet established standards before they're traded. Conflicts may also arise over the correct valuation of carbon allowances and offsets, or claims that carbon credits have been double counted either by multiple parties or across different carbon markets. Situations may occur where project developers fail to deliver the promised emissions reductions or carbon credits, potentially due to unforeseen circumstances like regulatory changes or natural disasters impacting the project. Disputes can similarly arise between project stakeholders and host states owing to, for example, regulatory changes or other government actions that affect the project or the functioning of the applicable carbon market. If a foreign investor is involved, these kinds of disputes can escalate into investment claims under a contract with the host state or under an international investment treaty that includes an investor-state dispute resolution mechanism. Conflicts may also arise over allegations that companies are falsely claiming or exaggerating the sustainability benefits of their participation in carbon markets. So these disputes involve accusation that companies are engaging in so-called greenwashing. Companies may also face accusations of misleading or deceptive conduct if they provide inaccurate information about their carbon credits or offsets or the overall environmental impact of a project. And as we've just heard from Alex, under Kenyan domestic law, there can be heavy penalties or even prison time for this kind of conduct. So some carbon market-related disputes may be effectively resolved through mediation or negotiations, which are neutral third-party facilitated discussions between the disputing parties to arrive at a mutually agreeable solution. A more formal dispute resolution method, which Alex and I are very familiar with, and that is frequently utilized in carbon market-related disputes, is arbitration. And in an arbitration, an impartial arbitrator or a panel of 3, typically impartial arbitrators, will review the evidence, hear the arguments from both sides, and issue a binding decision called an award. Many carbon market-related contracts contain a dispute resolution clause providing for the submission of disputes arising under the contract to arbitration. And to give an example, contracts between carbon credit standard bodies and third-party verification or validation bodies frequently incorporate an arbitration clause. The ability of parties to select arbitrators and to appoint experts with the necessary scientific or technical expertise is a major advantage of arbitration over other dispute resolution methods. The almost universal enforceability of arbitral awards is another significant attraction of arbitration. Other cases may be litigated before national courts, including where claims of greenwashing or misleading and deceptive conduct are involved. I would just add, not reflected on the slide, but at the state-to-state level, the UNFCCC contains provisions allowing for the submission of disputes arising in the context of that framework, including under the Paris Agreement to conciliation, which is much like interstate mediation or negotiation, or with the state's consent to the International Court of Justice or arbitration. And a panel of experts has been appointed to look at developing a conciliation annex to the Paris Agreement to help provide guidance for these kinds of conciliations. So looking ahead, as you'll be aware by this stage of your training, carbon markets are very complex. They involve a wide range of stakeholders, including governments, companies, project developers, all engaging in various kinds of often cross-border transactions. And as these markets grow and evolve, the likelihood of disputes will naturally increase. This could potentially result in the creation of more specialized international tribunals or other dedicated carbon trading related dispute resolution bodies. Whatever form they take, having efficient and reliable dispute resolution processes is crucial for ensuring accountability within carbon markets. And at the same time, robust dispute resolution mechanisms build trust among market participants, which allows the market to function smoothly and sustainably in the long term.
Thanks, Elise. I'm going to pick up there and get to what I hope is going to be seen as a more fun, even more fun and more practical part of our presentation. Now looking on onto risk management in carbon trading. So what are the main risks and what are the ways that both the legal framework and perhaps other apparatuses can deal with those main risks? We're going to cover 5 such risks: regulatory, market, operational, environmental, and technological. I think intelligent people could probably disagree on which risks fit within which categories. You'll see some market risks that look a little bit like they have an environmental aspect, operational risks that might have a regulatory aspect. This is just our organization. Don't think that there's any significance to the way we've categorized them, but beyond just having to organize our slides a certain way. Really, the key points to take home are, in substance, what are these risks and what are ways that a player in this system can help manage those risks, if not eliminate them. Starting with regulatory risk. The 2 main ones that we wanted to discuss are, first of all, the risk of policy changes, meaning as this very new system develops, we can see changes in law, changes in the way the law is interpreted, new regulations coming out. This could happen at the national level as well as at the international level. You know, there could be new treaties that change the entire landscape in terms of what are Kenya's obligations going forward with associated changes within the domestic legal framework. There's also the compliance risk that individual players within the system at the private level have to deal with. You have non-compliance with evolving regulations, potentially leading to penalties, potentially leading to exclusion from the market. How can these be dealt with? Well, there are 2 things within the current legal framework we wanted to point out. The first is that the DNA, the Designated National Authority, has the power to oversee project compliance, which mitigates some regulatory uncertainties. You know who to deal with. You know that the DNA has this role, and the DNA has obligations in terms of consistently overseeing, consistently reporting on what it's doing. So there's some level of transparency within the framework. In other words, you know who to look to for changes that are on the horizon. The other thing we wanted to point out, and I want to remind you of that slide with the various steps in the regulations for getting a project underway, is that the regulations are relatively detailed, relatively prescriptive when it comes to the procedure for developing and operating a carbon trading project. That, as far as I'm concerned, at least at present, leaves a little bit less leeway for uncertainty, a little bit less leeway for unexpected changes down the line. In addition, there are other things that can be done to manage these risks. Investors, for example, can seek to obtain the state's agreement in projects that are done through agreement with the state, that any changes in the law, any changes in policy won't apply to that particular investor or that particular investment. These are called freezing clauses or stabilization clauses. They're seen, for example, in the context of concessions for the exploration and production of natural gas or oil projects, where it said, for example, that the current tax regime, yes, it may change in the future for everyone else in the country, but as far as this investor is concerned, we promise it stays the same. More generally, mechanisms can be built into contracts, not just with the state, but with other private contractors to appropriately allocate the risk of legal and regulatory change. And you can always look to see what insurance policies are available for managing the risk as well. There's also market risk. I think this is probably the most obvious of the risks, so I'm not going to spend a lot of time here. But again, because this is a relatively new, relatively underdeveloped market globally and within Kenya, you have such risks as price volatility, pricing transparency is a big one. This is an asset. The carbon credit is an asset that is intangible. It's something that's quite new. And so we haven't yet, I think, agreed internationally on standards for pricing and what the price is actually based on. And you also have market perception risk, meaning there can be negative perceptions or criticisms about how a market is being conducted, which can then have outcomes, can then have impacts on individual players within the market. So how are these managed? Well, within the legal framework, you have the National Carbon Registry. This should help enhance market transparency and help stabilize prices by tracking carbon credit transactions and preventing manipulation. You also have detailed regulations around carbon projects, which also link back to international standards. While the regulations don't name standards, they do require certain aspects of carbon trading to be done in accordance with international best practice. And you have regulations requiring as well that project proponents submit annual project reports to the DNA, which provides detailed information on what they're doing. So there's that other aspect of transparency involved. In addition to what the law provides, companies should also consider what warranties and termination rights to include in their contracts so that they ensure that they're adequately protected in case things don't go as expected. They should also seek consistent reporting from project developers they're working with. And they should look at collateral requirements and credit assessments and third-party guarantees in case something goes wrong so that they have some security that they can fall back on, they can call on in case the project developer that they're working with is unable to make good on whatever wrong it's committed. The next risk is operational risk. Here we have such things as trading errors and fraud and manipulation. I think we've covered a bit of this already in the last slide on market risks, but really the main points here are that you have a national carbon registry and a DNA who perform an active monitoring role. So it makes it a bit more difficult within the Kenyan system to have fraud and manipulation, at least at that level. You also have specific provisions within the regulations on penalties for fraudulent activities. We saw at the end of the slides on the regulations that there is a 500 million shilling penalty plus a maximum 10-year imprisonment for such offenses as fraud or even failure to report. So those tend to manage risk, we think, from the fraud and manipulation perspective. In addition, we think contracting parties should ensure that their contract terms and the applicable law provide a satisfactory remedy in case there is a mistake in the contract negotiation phase that has a material impact on them. And we also think that standardization efforts, for example, by the Integrity Council for the Voluntary Carbon Market and the Voluntary Carbon Markets Integrity Initiative, we think these are creating frameworks for improving integrity and transparency in voluntary carbon markets on an international scale. And you'll hear a little bit more from us on those when we get to future developments. On environmental risk, there are three that Elise has touched on already a little bit, and you also heard a little bit on these in the first training session. The first is additionality, so that's ensuring that carbon reduction projects represent an actual additional emissions reduction that would not have occurred but for the project. There's also leakage, preventing the displacement of emissions to areas outside the carbon market's jurisdiction to ensure that there's actually on the global scale a net reduction in carbon emissions. And also greenwashing, which is addressing the risk of proponents falsely, misleadingly claiming or exaggerating the project's environmental benefits. So how are these dealt with? On the legal side, we have in the regulations the requirement that all project proponents provide accurate and comprehensive reports on their activities, including a detailed accounting of carbon credits issued and traded. We also have the mandate that environmental and social impact assessments and corresponding adjustments to uphold environmental integrity on the global scale are in place, and that is to prevent double counting. So there are mechanisms within the legal framework that manage these risks. In addition, there are rating agencies that can be used to help increase transparency. They can provide some objective clarity on the overall integrity of carbon credits from particular projects. With respect to greenwashing in particular, we think that project proponents should be careful about what they say about their projects to avoid making any statements that could be considered as exaggeration or as anything tantamount to greenwashing. On the buyer side, though, we think that buyers should perform adequate due diligence before getting involved in a project or buying carbon credits. And they should do that with the assistance of qualified experts to make sure that they're not getting involved in an exaggerated project or one that's fraudulently or misleadingly stating its results. Technological risk. Technology is oftentimes a great help, but it can also be a point of pain when there are, for example, disruptions due to system failure or cyber attack. There's also the risk that technology can evolve too rapidly and leave you with obsolete technology, which on the project side also raises the risk of stranded assets. What is a good technology today for reducing carbon emissions might in a year's time or a few years' time be obsolete, in which case there's a risk that the project has nowhere to go. It's seen a lot of investment, but it's standing there and unable to produce. Within the legal framework, unfortunately, we don't think that there are any specific legal mechanisms currently in place that deal with these risks, at least not directly. So we think that the players in this market will have to look to additional risk management mechanisms. And there are two in particular we wanted to highlight. The first is making sure that you're protected from a cybersecurity and data protection standpoint. So make sure that you've discussed with cybersecurity experts, and to the extent you're relying on technology, you're using cutting edge solutions that aren't overly vulnerable to these particular risks. And we would also take steps to understand the possible technological developments that are in the pipeline, so you're not left with a project that is obsolete from the get-go and one that's unable to produce at the level that was originally envisaged. I'm aware of the time, but we have just a few more slides to share with you, as well as hopefully some time to address some questions of yours. The next session, the next section of this we want to deal with is what's next, potential developments. The first one that we think is worth considering is the emergence of new voluntary carbon markets. Much like what's happened in Kenya quite recently, there are a number of other jurisdictions globally that are looking to establish voluntary carbon markets. What can this mean? First of all, it can mean increased competition between markets. Kenya, for example, if it wants to attract foreign investment, it may need to distinguish itself from other markets that are looking also to attract foreign investment and looking also to expand and become the go-to market for carbon trading. This may, on a positive note, also lead to further attempts at harmonization and standardization across jurisdictions, because as there are more and more markets, there also becomes a need for standardization across those markets. There are people who are going to be trading across markets, and new markets are also going to want to look at what others have done successfully to avoid reinventing the wheel and make sure they're incorporating good lessons learned. So this would be a positive development in terms of standardizing and harmonizing. We may also see greater innovation in carbon offset projects, but this, as we've said at the end of the risks slide, is a double-edged sword. On the one hand, technology advancements always good in at least some respects because we assume that they're more effective, more efficient. On the other side, projects that are under development or in train run the risk of becoming prematurely obsolete, which can be a risk for the project proponent.
Thanks, Alex. This means that carbon offsets are increasingly being viewed by governments as sovereign assets, much like any other natural resources such as oil or minerals. As a result, many governments are taking steps to exert greater control over their carbon reduction potential. And this shift in policy could limit or constrain private sector involvement in carbon markets as governments seek to maximize the benefits for their own economies. And a variety of measures have emerged as governments aim to capture more value from carbon trading. We've identified a few examples on the slide. Zimbabwe notably has imposed taxes on carbon credit transactions to ensure that a portion of the profits flows back to the state. Papua New Guinea, following a similar approach to Kenya, has introduced a mandatory benefit sharing regime. Benefit sharing ensures that a portion of the benefits from carbon credit projects are distributed to local communities or to the local government, typically. I saw a question in the comments about how we can ensure that human rights are protected throughout this process. Benefit sharing is an example of how this can be done. Typically, it also requires, as the Kenyan system requires, we heard from Alex, that project developers have to obtain free, prior and informed consent, or FPIC or FPIC, which is aimed to establish the bottom-up participation of local communities prior to the beginning of a project, but also throughout the project's lifespan. India has taken a much more extreme step of banning altogether the export of carbon credits generated within the country. And this policy is aimed at keeping carbon credits within India to allow it to meet its own emission reduction targets rather than being sold on international markets. So all of these measures reflect a growing trend of so-called carbon nationalism.
Next up is technological developments. As you can see, we think technology will be quite important in all of this. There are two in particular that we think could be game changers for the development of not only Kenya's carbon market, but carbon markets globally. The first of those is further innovations in blockchain technology. Blockchain, you may have heard of more in the context of cryptocurrency. Essentially what it is a digital ledger, a digital book, if you will, that records transactions in a way where no one person is responsible for the book. It depends on everyone in the system interacting, each person in the system interacting with one another. And what that means is no one can make changes. So this provides, at least in theory, for, first of all, transparency, everyone can see what's in the ledger. If we're, for example, using it to record the verification of a carbon credit at the point of production, or the trade of a particular carbon credit, or if we're using it to record additionality, if we're using it as a way of avoiding double counting. So it's both transparent, and it can also make sure that fraud isn't coming into the mix and undermining the system's legitimacy. The other technological advancement that we see as being a potential game changer is improvements in what we would call remote sensing, most notably satellite technology and drones. What can those do? Those can facilitate real-time monitoring of projects, both as the project is being developed to ensure that it's not having negative impacts that are wildly beyond those that were stated in the environmental and social impact assessments, but also during the operational stage to make sure that this is a check against things like greenwashing, that what the project proponent is saying about the impacts of the project are actually being borne out in real time. And you can see that, for example, on a reforestation project by looking using a drone or a satellite at what the project is actually doing in real time.
The last future development that we thought was worth mentioning today was this increasing pressure on companies, which is coming from states, international organizations, and other civil society groups, for companies to cut emissions directly instead of relying on carbon credits. And this movement really emphasizes that purchasing credits shouldn't be a substitute for achieving actual emission reductions in connection with a company's operations. So going forward, we can probably expect stricter regulations requiring businesses to show real emissions reductions. And in a recent crackdown on misleading environmental claims, the European Union has already banned the use of offsetting to substantiate terms often used by companies in promoting their goods or services that they are climate neutral or climate positive. So we can perhaps expect other governments to follow suit. The European Union also requires companies to report their actual emissions reductions separately from their carbon offsets. We may see similar requirements being adopted elsewhere. And at the same time, companies that rely heavily on carbon credits are likely to face heightened scrutiny with corresponding liability and reputational risks. And that, I believe, brings us to the end of the presentation, slightly over time.
We had planned to do a quick wrap up. If you allow me just a few seconds to do that, because I think it is time well spent. What we've covered is the carbon trading framework and how it looks at present, focusing in particular on the laws, regulations, and players that give that shape in Kenya. So the main takeaway from the discussion, we hope, is, first of all, that the legal framework is fairly prescriptive, with quite detailed procedures and requirements that need to be understood by any stakeholder in the system. As we're going to do the traditionally lawyerly thing and give you a caveat, neither Elise nor I, as I'm sure you would have expected, is qualified to practice law in Kenya. We are not Kenyan law experts. We are giving you the lay of the land from a different perspective, notably as international lawyers, as international dispute resolution and risk management specialists. So if you have any questions about how this system works, specifically what requirements you may need to meet in order to get a project up and running, for example, you need to go to a properly qualified Kenyan lawyer to get those answered. It's also important to bear in mind, and turning back to the main takeaways, that there's such a crucial role played in all of this by communities. And this is going to build off of what Elise just said about not only human rights, but also some questions about Indigenous people. Communities may not have had the voice that was required in actually formulating the policy, but there is a clear role for impacted communities to play in making sure that projects at least don't harm them economically, socially, and culturally. So there are assessments that need to take place before a project is underway. There are agreements that need to be in place with communities to make sure that they are properly benefiting from any projects that take place in their surrounding areas. We've also looked briefly at the key risks and management of those risks. The message we wanted to leave you with there is that while the legal framework generally seems fit for purpose and consistent with international practice, there are a few areas where proper risk management will require additional steps from stakeholders within the system, whether through intelligent contract drafting, due diligence, expert interventions, etc. And finally, we've considered some potential developments that can impact carbon trading, again, not only in Kenya, but globally. In the next training session, you'll hear from our colleagues on two topics in particular, certification of carbon credits and relevant standards attached to those, as well as on international best practices on carbon regulations. It's been an absolute pleasure sharing our thoughts with you today, and we wanted to open the floor now to any questions you may have.
Thank you very much, Alexander and Elise, for taking us through that very insightful session. I'm going to invite my colleagues. I will invite my colleagues, Anne and Teresa, if they're able to pick some questions. Maybe if you can give us about 10 minutes maximum. Would that work for you, Elise and Alexander? We can do 10 minutes Q&A.
We're at your disposal. We're happy to do as much as you're willing to do.
Great, thank you so much. Teresa or Anne?
Thank you so much, Alexander and Edson. That was very informative, and I can see from the comments, starting with the comments, that the session is very informative. The topics are well thought through. There's a great summary of the genesis of carbon markets. And yes, we will share the slides with all those who are here today. So thank you for that very informative session. There are quite a number of questions. On the Paris Agreement, Rosalind is asking whether private entities involved in the market arrangements established under Article 6 of the Paris Agreement, are private entities involved in the market arrangements? And there's a basic question on what or where are the voluntary carbon markets based? So let me ask a couple of other questions, and then we can pause, you answer, then we proceed with the other question. The next question is on social and environmental benefits, some of which you have already tackled, questioning whether communities have a right and what should happen when such communities are evicted from their homes in order for voluntary carbon market and trading to take place. And the other question is on social risks. Do you think that these are overlooked, Alexander? Then the other question on community, Okoth is asking whether county governments are part of the institutional structure for carbon markets in our laws, in the Kenyan laws. And on the same question, we also have a question on regulations. That is, do regulations capture the interest of humanitarian, social, and corporate aspects when designing and drafting these carbon market laws and regulations? It's as though some communities are often forgotten. That is the indigenous farmer, the pastoralist, the hunter, and the gatherer. Again, on community and regulations, Basel is asking, how can the law or the legal system be used to protect the carbon rights for indigenous people? Perhaps you could answer those first, and then we'll take the next set on credit auditors and arbitration.
Thank you very much. How do you want to divide this? You want to?
I think the first question I can answer quite quickly. It concerns the Article 6.4 mechanism of the Paris Agreement. And if I understood the question correctly, it was, are companies involved in this market that is being developed? And the answer is, look, the Paris Agreement is a state-to-state instrument, and the mechanisms are primarily designed for states. That said, the carbon credits generated pursuant to this Article 6.4 mechanism can be traded in voluntary carbon markets. So yes, companies can get involved through the voluntary carbon market.
On the second question, what happens when communities are evicted for projects to take place? Horrible situation, though not completely inconceivable. There is no specific regulation or provision that deals with that scenario, at least as far as I'm aware, in the Act or the regulations that we've looked at today. There are more general requirements requiring, above all, that any project needs to take into account potential impacts, and that's not only environmental impacts, it needs to take into account social and cultural impacts as well. And this is also going to address another question that was asked, including that went to what extent communities are involved in the process. For a project to get approved, it needs to be positively recommended by what's called an ad hoc committee that belongs to, in essence, the designated national authority. And that ad hoc committee needs to be interdisciplinary and composed of what's referred to, I think I'm paraphrasing here, please don't quote me, an appropriate cross-section of society. And I think there's specific references to local communities being involved there. So all of this to say, if there's going to be an impact to a project that is wildly outweighing the potential benefits, perhaps because it's going to displace a community, then I'd like to think it wouldn't be approved on that basis. However, there are also, all the way up to the constitutional level, constitutional rights to a healthy and safe environment. And these also mix in with dispute resolution, in the sense that if somebody is deprived of a healthy and safe environment, they have direct recourse through the government. I don't recall exactly which court they can apply to. If you give me a second, I think I can tell you. But the punchline to this is there is an avenue of recourse to people who have been wronged on a human rights level by a project, or indeed by anything else that the state has done. I'm not finding the particular provision in the Constitution, but I'll come back and let you know if I find it. I think the next question was for me as well. That was on social risks. Are these being overlooked? Probably yes. I don't think there's ever going to be a... Sorry, can everyone hear me? Okay. I don't think there's ever going to be a perfect answer to making sure that social risks, that local communities' voices are being heard, because by definition, they're not in the leadership role. They're not the ones who are promulgating these laws. They're not the ones who are promulgating these regulations. I wasn't involved with the process for the the process according to which the regulations came to be. So I can't speak to what level of involvement local communities had there, but in any event, it doesn't seem from the questions I've been asking that they were directly involved, at least to any meaningful degree, in that process. So to answer the question in a few words, yes, probably overlooked to some extent, but I think that the key to bear in mind throughout all of this is that the Kenyan system is an improvement, at least against what we've seen in other jurisdictions, just because of the basic fact that it does speak to benefit sharing, it does speak to social welfare, to cultural welfare, at least to some degree.
Teresa, can we have the next batch of questions? I think we do the last one in the interest of time, because I can see participants already dropping off. Teresa?
So sorry, can you hear me?
Yes.
Okay. So is it a risk, Alexander, if food security is overlooked at the favor of carbon credits? That is, there are many farmers giving out their lands for tree projects at the expense of food production. Secondly, for credit auditors, Maurice is asking, what is the position of credit auditors at this point? And the last set of questions is on arbitration. Can arbitration be done through the financiers' dispute resolution mechanism? And secondly, on ensuring fairness, equity, and justice in carbon markets, there's a lot of injustice on the prices for carbon projects in developing countries. Therefore, how can developing countries get better prices for the carbon credit? Lastly, there's a question on transparency, integrity, and accountability in the carbon market value chain. How can this concern be best addressed for sustainable carbon credit markets? And the last question, I think this goes to Jabez. What is the role of the East African Wildlife Society in ensuring sustainable partnership with grassroots CBOs beyond this session of training? Back to you.
Sorry, Teresa, can I just ask on the second to last question about accountability in the value chain? What was the end of what you said? I didn't quite catch it.
Yes. How can we address sustainable carbon credit market in light of ensuring transparency, integrity, and accountability in the carbon market value chain?
Let me start with the question about carbon offset projects being potentially at the expense of food production. I would just reapply what we've said already about other potentially negative impacts, including the extreme scenario where an entire community might be displaced, might be asked to leave the land. I don't think it's necessarily out of the question, but I do think that there are specific mechanisms in place all the way up to the Kenyan Constitution that deal with communities being negatively impacted by projects like this. At the end of the day, I think in terms of the approval process for a given project, determining whether or not it should become operational, it's going to be a cost-benefit analysis. And that sometimes can be a blunt instrument. It sometimes can be one that doesn't have the necessarily the humane approach that we would hope for. But the hope is that once the Kenyan system becomes more developed and gets underway, that the inclusion of a number of different people from a number of different disciplines at high levels in the system, notably within the ad hoc committee that I discussed earlier, within the Climate Change Council, that those voices will lead to decisions, lead to results that are more reflective of Kenyan society as a whole. There was a second question about the role of credit auditors. Because the market in Kenya is fairly new, including to me, I'm not sure yet how present they are there, or what it takes to get creditors, what it takes to get auditors involved, or what they do or don't know about your particular market. What I do know is that in other jurisdictions, notably within the European Union, there are a number of independent auditors that have become quite sophisticated and who are now part of what I think is international standard practice in terms of verifying that a project is doing what it says, that there's integrity in terms of carbon credits being called carbon credits, and integrity in terms of the trade in carbon credits. So there is already a discipline for auditing those things. Do you want to handle the arbitration?
Could I actually?
Yeah.
Could I hear the question again, please? I missed. This is the arbitration related. Can arbitration be used to resolve disputes between, but then I didn't quite catch the parties. I can say more generally that arbitration is a consent-based dispute resolution mechanism, which means that both parties have to consent to have the dispute resolved before an arbitral tribunal, unlike before domestic courts where parties can be brought in involuntarily. So typically when you're referring to disputes between private parties, there is a contract, and that contract includes an arbitration clause that records the parties' consent agreement to submit any dispute arising under that contract to an arbitral tribunal. So I'm sorry, I didn't catch the exact relationship that question was directed at, but certainly those general principles would apply across the board. I think the next question was to Jabez.
No, there's a question on how developing countries can get better prices, if I heard correctly. I don't think I could ever give a complete answer to that question because there's so many different variables.
Michael, could you please unmute the speaker?
Okay, sorry, I don't know what you'd have missed. The point is there are many variables that go to pricing, but looking at this very generally, I think one of the key variables that's going to put downward price pressure on carbon credits in markets from so-called developing countries is going to be probably buyers' perception, buyers from elsewhere's perception that those economies are less developed, that there are less modern apparatuses in place to, for example, deal with the verification of carbon credits, auditing to make sure that projects are actually doing what they say, and that there's a minimum risk of fraud and misstatements, things of the like. So it's going to take two things. It's going to take, first of all, the actual apparatus to do those things. And Kenya, I think, at least based on my knowledge of other systems, has a pretty good framework already in place to tout itself as a modern, well, it's almost silly to say modern carbon trade market because they're all modern by definition, but one that I would say is more cutting edge. But I think that's only half the battle. I think it's also going to be incumbent on leaders, so at the political level, as well as civil society, as well as stakeholders within the system, straight down to private investors who are interested in Kenya's carbon markets, to make sure that the rest of the world knows that all of those apparatuses are in place and that Kenya is a safe place to invest when it comes to carbon markets. I think another thing that can be done to put people at ease and eliminate any risk of there being downward price pressure is to standardize and harmonize with best practices in the rest of the world as much as possible. And that would include things like getting auditors from elsewhere to come in and do work within Kenya. It would mean things as well as incorporating within regulations some of the international standards, not just at an international level, but even at a private level that we've seen. I hope that answers the question.
Yeah, thanks, Alexander. I think the question that was posed to me was on the role of East Africa Wildlife Society in ensuring sustainable partnership with grassroots CBOs. I think I'll answer this in a simple way. East Africa Wildlife Society hosts 2 national forums. One is called Kenya Forest Working Group, and we also have Kenya Wetlands Forum. So these are platforms that bring diverse stakeholders that, in one way or another, are doing work related to forest and also wetlands. We believe by the CBOs being part of such forum, they are able to, link with other stakeholders. So I think to me that is one of the critical way in which we ensure, sustainable partnership. The other one is just providing also linkages. Like now the partnership that we are having with A&O Shearman and also with International Alliance Project. We've now had other CBOs and other stakeholders benefiting from the partnership that we have by creating the linkages. Yeah, thank you.
Thanks. Are we done with there's so many questions coming in and we may not have enough time to answer all of them at the moment. So we'll put them all together and share them with our presenters. If they have time to respond, and it will be part of the response after this session. Thank you. Back to you, Jabi.
Can I just say very quickly that there's also the possibility of organizing future events where we can include a discussion of some of those questions as well. I'm very happy to see questions. I love that this has spurred debate and that this has spurred really intelligent questions about how to or how the framework has come about, but also how to deal with it. I guess the final thing I would say is, at the risk of speaking for Elise as well, we love what we do, and we're here to assist if, outside the framework of this event, we could be of need or of use to anyone who wants to get involved in carbon trading.
Great. Thank you so much, Alexander and Elise, for taking us through this important and very informative session. I think we've really enjoyed it, even looking at the comments that we have been posted on the chat box. And like you rightly put it, Alexander, we are looking forward to organizing more trainings that could revolve around some of the areas that people are asking questions about. So I think once we're done with these sessions, we can retreat again and just look at some of the areas that stakeholders are interested in learning about, and then we can now organize another series of training. So thanks so much. I also want to take this particular opportunity to inform the participants that we have posted a link to the evaluation form. It's really important that you give us feedback so that then we are able to improve or even make future trainings much better. So kindly spend a few minutes to just give us your feedback so that then we can use that for the subsequent trainings. The next session will happen on the 18th of this month. So that is not far from now. So we are looking forward to having all the participants who are here today, even in that the upcoming training session. We will share the training materials, including the PowerPoint presentation, as well as the recording for your reference. So we can rest assure you that after this training, we'll be able to share all those materials for your future reference. The last thing I would like to mention is that for us to continue having this conversation, we want to invite you that you join East Africa Wildlife Society so that you support our work. You can also join the 2 national forums that I mentioned earlier. We will be sharing the link when we'll be sending the communication after this training so that you can be part of those platforms. It will actually open, a window for more opportunities in future. So I think that's something important to mention. Also to invite you for our upcoming event called Forest Challenge. So this is an event that we hold every year. It's a fun, competitive event that we do right inside the forest. And of course, the overarching goal is just to mobilize resources that plow back into our restoration work. We will provide you with a link to the Forest Challenge website for you to get more information. And of course, we look forward to your participation. As an organization, we also hold quarterly talks called Imre Lofla Talk. These are very insightful talks where we bring seasoned, experienced, experts to share their opinion regarding certain topics. So these are physical, talks that we hold here in Nairobi and also in Nanyuki. So we will be able to share with you when we will have the next training, who the speaker will be, and we look forward to you participating in the same. So I think without further ado, I just want to give an opportunity to Lucy or Maria from International Lawyers Project just to say a word before we can conclude. Maria, welcome. Mike, kindly unmute Maria. Like we mentioned earlier, this training has been organized by 3 institutions, that is International Lawyers Project and also A&O Shearman. ILP has played a critical role in terms of even just connecting us with A&O Shearman, so we can't go without noticing them. Right. Maria, welcome.
Thank you, Jabez. First of all, thank you to East African Wildlife Society, our partner in this project, for hosting the training. And of course, we're always happy as ILP to support your activities and projects. And I'd also like to commend the excellent presentation from our trainers today, Ellis and Alexander. Thank you so much. And we hope we can work further with all the parties here in the future.
Thank you so much, everybody, for staying throughout the training. We really appreciate that. And now we have come to the conclusion of our today's session. We look forward to having you all in the session that will be taking place on the 18th of this month. Enjoy the rest of your day. Bye-bye.